Appeal Part Head in the matter of Bank Ltd and others, and DFCU Bank Ltd and others.
Good morning, my lords. I was about to embark on the materials following Lord Templeman's observation, the materials which we say establish the public policy of the relevant public policy of this jurisdiction. And first, can I take your lordships, please, to the Bribery Act 2010, which is in Authorities Volume 8, behind tab number 47 at electronic page 2305, and Parliament intervened to specify that bribery is not just a criminal offence if carried out in this country. Bribery of foreign officials may also be a criminal offence in this jurisdiction. And we see at section 6, subsection 1, a person P who bribes a foreign public official F is guilty of an offence if P's intention is to influence F in F's capacity as a foreign public official. And there's a broad definition of foreign public official at section 6, subsection 5. Section 11 of the Act shows how seriously Parliament takes the offence on conviction on indictment. This is section 11.1. The court can sentence the offender to imprisonment for a term not exceeding 10 years or to a fine or to both. Section 12 deals with territorial application. 12.1, an offence is committed under the primary sections if any act or omission which forms part of the offence takes place in that part of the United Kingdom. Then there's a further provision, subsection 2, subsection 3 applies if no act or omission which forms part of an offence takes place in the United Kingdom. A person's acts or omissions done or made outside the United Kingdom would form part of such an offence if done or made in the United Kingdom, and C, that person has a close connection with the United Kingdom. And subsection 4 defines what is meant by a close connection. That is satisfied if the person is a British citizen, that's A, or H, many others, H, a body incorporated under the law of any part of the United Kingdom. In this case, as your lordships may have seen from our re-amended particulars of claim, which is core bundle 7, looking at page 93, we see that two of the defendants, the 10th defendant and the 11th defendant, are British. That's paragraph 7A and B. And the 6th defendant in this case, CDC Group, is a limited company incorporated under English law. We see that at paragraph 6A on page 92. CDC Group is a limited company incorporated under English law. It's a development finance institution, and it's actually wholly owned by the UK government. It's invested over £5 billion in companies operating in Africa and South Asia. We say in the pleading that it's played an integral role in the long-term growth of the DFCU Bank over the last 6 decades through multiple debt and equity funding rounds. I'm not suggesting, can't suggest, because we don't have the material, that these two individuals, one corporate entity, have committed criminal offences. The disclosure of material that we hope to receive may enable us to sustain such claims. My Lords, when this bill came before Parliament on the second reading, the Secretary of State for Justice and Lord Chancellor, Mr. Jack Straw, made a statement which emphasised the international dimension of the mischief of bribery. And I draw attention to this. I'm, of course, well aware of the limits of pepper and heart, but I'm drawing attention to this simply to emphasise the mischief at which this legislation was aimed. And your lordships will see the statement that was made to Parliament at volume 9 of the authorities, and it's behind tab number 60. It starts at electronic bundle 2616, volume 9, tab 60, and if your lordships turn over to 2617, there's an interesting anecdote about the late Michael Foote that is worth reading, but I won't detain the court on it.
So where are we?
And on page 2617, electronic 2617, just before the middle of the page where it says 3rd of March 2010, just above that, the 2 paragraphs above that, Mr. Straw tells us this: bribery, as we know, is an insidious offence. It undercuts honest companies, it distorts the free market, it causes state institutions to lose their legitimacy and public confidence in the political system to wane. Where bribery is allowed to flourish, democracy struggles to take root. Its impact on development is equally damaging. Bribery discourages foreign aid, it feeds inequality and injustice, diverts valuable funds away from basic public services. The rich get richer, the poor get poorer, and the most vulnerable in society are hit the hardest. One of the consequences of bribery and the misuse of development funds, whether they come from the state or from charitable causes, is the undermining of public support in wealthier countries, including this country, for continuing that assistance. The scale of bribery across the globe is immense. We have to rely on estimates, and although there's no precise estimate of fraud or bribery, the World Bank has estimated that some $1 trillion is paid annually in bribes, adding around 10% to the cost of doing business in some countries. There is both a moral and a practical imperative for tackling bribery. As a nation reliant on world trade for our prosperity, the United Kingdom is duty-bound to set an international example in stamping out this scourge. Changing the law on its own, whether in the context of bribery or any other sphere, is necessary, but of itself not sufficient. The bill is therefore one part of our wider strategy to tackle bribery by supporting ethical business practices in British companies enforcing the law effectively and working with our international partners to promote good governance overseas. And then a little further down, some 4 paragraphs from the end of the page, there's a paragraph that says the core element of the bill can be briefly described. He refers to clause 1. Clause 6 creates a bespoke offence of bribing a foreign public official in order to obtain or retain a business advantage. The UK takes its international obligations seriously. This House should be in no doubt our law is already compliant with the various international conventions combating bribery to which this country has put its name. This specific offence will underscore our adherence to the OECD's Convention on combating bribery of foreign public officials in international business transactions. And I adopt all of that as a very helpful statement of the mischief of bribery internationally. Now, the convention to which the United Kingdom is a party, the main convention, is the 2003 UN Convention against Corruption. And your lordships will find that convention at volume 8 of the authorities at tab number 54. It's electronic page 2446. United Nations Convention Against Corruption. And we rely on the preamble, because the preamble explains the mischief, the serious mischief of bribery and corruption. And the preamble tells us that the states parties to this convention, the United Kingdom is a party, as indeed is Uganda. Both signed and ratified this convention. The state parties to this convention concerned about the seriousness of problems and threats posed by corruption to the stability and security of societies, undermining the institutions and values of democracy, ethical values and justice, and jeopardising sustainable development and the rule of law. And I emphasise those words because, as I showed you, Lordships, yesterday, Lord Hope drew attention to the importance to public policy of this country of the rule of law internationally in the Kuwait Airways numbers 4 and 5 case. It was authority, I don't ask the court to go back to it, but it was Authorities Volume 2, tab 11, and it was Lord Hope at page 1110, paragraph 145. So that's the first paragraph of the preamble. The second paragraph deals with the links between corruption and other forms of crime. And then the third paragraph concerned further about cases of corruption that involve vast quantities of assets, which may constitute a substantial proportion of the resources of states, and that threatens the political stability and sustainable development of that states. Convinced that corruption is no longer a local matter, but a transnational phenomenon that affects all societies and economies, making international cooperation to prevent and control it essential. Convinced also that a comprehensive and multidisciplinary approach is required to prevent and combat corruption effectively. Then there's a reference to technical assistance, and then at the bottom of the page, convinced that the illicit acquisition of personal wealth can be particularly damaging to democratic institutions, national economies, and, the phrase again, the rule of law. Then over the page, I draw attention to the third paragraph, bearing in mind that the prevention and eradication of corruption is a responsibility of all states, and that they must cooperate with one another, with the support and involvement of individuals and groups outside the public sector, such as civil society, non-governmental organisations, and community-based organisations, if their efforts in this area are to be effective. We then turn to the contents of the convention at page 2448, Article 1. The purposes of this convention are A, to promote and strengthen measures to prevent and combat corruption more efficiently and effectively. B, to promote, facilitate and support international cooperation and technical assistance in the prevention of and fight against corruption, including in asset recovery. And C, to promote integrity, accountability and proper management of public affairs and public property. Going through the convention, I won't read all of the provisions, though I'm happy to read any that my friends want me to. Article 4, Your Lordships, may wish to look at on page 2450, protection of sovereignty. States parties should carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states, and that of non-intervention in the domestic affairs of other states. We understand that to relate to state immunity, not to the FAS doctrine, not least because the FAS doctrine, as your lordships have seen, is not an international law principle. See Maduro, Authorities 7, number 34, at paragraph 1 through 5, and Belhaj, I've shown the court these references, Belhaj, Authorities Volume 4, tab 22, paragraph 118, Lord Neuberger, and paragraph 200, Lord Sumption. Article 8 is on page 2452. Article 8.1, in order to fight corruption, each state party shall promote inter alia integrity, honesty and responsibility among its public officials in accordance with the fundamental principles of its legal system. Then Article 15 on page 2458, bribery of national public officials. Each state party shall adopt such legislative and other measures as may be necessary to establish as criminal offence when committed intentionally various acts of corruption and bribery. Article 16 deals with bribery of foreign public officials and officials of public international organisations. Each state party shall adopt such legislative and other measures as may be necessary to establish as a criminal offence when committed intentionally the promise, offering or giving to a foreign public official or an official of a public international organisation directly or indirectly of an undue advantage, etc., in order that the official act or refrain from acting in the exercise of his or her official duties or to retain some other advantage. Article 26 on page 2462 addresses the liability of legal persons. Each state party shall adopt such measures as may be necessary, consistent with its legal principles, to establish the liability of legal persons for participation in the offences established in accordance with this convention. Subject to the legal principles of the state party, the liability of legal persons may be criminal, civil, or administrative. Such liability shall be without prejudice to the criminal liability of the natural persons who committed the offences. And 4, each state party shall in particular ensure that legal persons held liable in accordance with this article are subject to effective, proportionate, and dissuasive criminal or non-criminal sanctions, including monetary sanctions. And Article 35, which is on page 2467, addresses compensation for damage. And Article 35 says this: each state party shall take such measures as may be necessary in accordance with principles of its domestic law to ensure that entities or persons who have suffered damage as a result of an act of corruption have the right to initiate legal proceedings against those responsible for that damage in order to obtain compensation. On Article 35, we draw attention to the UN review which was carried out in 2010 to 2015 of state parties to assess the extent to which they were complying with their obligations under the UN Convention. And we say it's of interest and importance that the United Kingdom was relying on the availability of tort claims under civil law, under the common law, as its compliance with Article 35. And we see this in, there's a volume called Supplementary Authorities bundle. Hopefully we should receive this Supplementary Authorities bundle.
What that I'm aware of. Oh no, hang on, could be. Yep, here we go. Which one? Yep.
Supplementary Authorities bundle. It says on the front tabs 1 to 6, and the relevant document is document 3.
Mm-hmm.
I don't know whether my Honourable Justice Phillips has.
So which tab?
It's tab 3, and it's a country review report of the United Kingdom. And can I invite the court's attention to page 8. Yes, it's page 8 of the document, but it's the electronic numbering 7 at the bottom of the page. It's paragraph 46, 45 and 46, and the heading is consequences of acts of corruption, compensation of damage, and it refers to Articles 34 and 35. And it's dealing with Article 35 in paragraph 46, and it says, furthermore, for individuals who have suffered financial damage as a result of acts of corruption, UK law enables them to pursue compensation from actors involved in such action when these actors intended or were aware that damage was going to be inflicted, even if a public authority is complicit in a corrupt process. And there's a bit more detail about that on the next page, which is electronic page 8. And it's, Your Lordship see, about an inch down, the heading is Article 35, Compensation for Damage. And the contents of Article 35 are then set out. Each state party shall take such measures. And the information relevant to reviewing the United Kingdom's implementation of that article says this: the state under review has provided, so the United Kingdom has itself provided 4 examples of economic torts that could be applied in cases of damages inflicted to an individual as a result of an act of corruption, namely deceit, conspiracy, intimidation, and intentional harm of economic interest by unlawful means. And the tort of deceit is then set out, and then the tort of conspiracy assumes 2 forms, the first of which is unlawful means conspiracy. And there's then some observations on the implementation of Article 35, and I draw attention over the page, electronic page 9, to the last 10 lines of paragraph 240, beginning on the question of whether a remedy is available where a public authority is alleged to have been complicit in a corrupt process which can be shown to have resulted in damage to the claimant. The UK confirmed that this would be capable of falling within one of the economic torts previously identified, and they're then set out, though which one would depend on the particular circumstances of the case. And this would allow for damages to be claimed from the public authority if they were found to be complicit. So the United Kingdom is recognising, correctly in my submission, that Article 35 does impose obligations in relation to civil claims for damages. My friends point out in their skeleton arguments, and I don't dispute this, that the main thrust of the UN Convention is concerned with criminal prosecution and criminal jurisdiction. But there's 2 answers to that. First, there's the Article 35 point, which I just addressed, that Article 35 is concerned.
Oh, that passage you just referred us to,
Yes.
which talks about the law of tort, makes it
Yes.
clear that it's talking about civil.
Indeed. And that's an implementation of Article 35, which itself clearly says so. And the second point I make, I've already shown your lordships the passage in Belhadge, where Lord Sumption said that the criminal law, I'm quoting him, the criminal law reflects the moral values of our society and may inform the content of its public policy. That was Belhadge, paragraph 266, Authorities, Volume 4, tab 22. So there's a very clear and profound statement at international level in a convention to which both this country and Uganda are parties, that corruption and bribery are matters that go to the heart of public policy. They are international mischiefs of very, very considerable gravity, which it is the obligation of states to address, to prevent, to deter, and to remedy by civil and criminal means. It is also true, as my friends point out, that the UN Convention does not impose obligations on this country to adopt universal civil jurisdiction in relation to corrupt acts. The lordships will be aware in relation to torture, the United Nations Convention imposes an obligation for universal criminal jurisdiction. We don't see that, as my friends point out, in this UN convention. But this case is not about jurisdiction in that sense. There's no dispute that the court has jurisdiction over these respondents subject to the FAS doctrine of domestic law. There's one other important convention to which I draw the court's attention, and that is the Council of Europe Civil Law Convention on Corruption, 1999. This convention has been signed by the United Kingdom but not yet ratified by the United Kingdom. And your lordships will see this convention at volume 8 of the authorities at tab 52. And looking at the preamble, it's in the 6th paragraph of the preamble. This is electronic page 2441, tab 52 of volume 8. In the 6th paragraph of the preamble, we're told that the parties are convinced of the importance for civil law to contribute to the fight against corruption, in particular by enabling persons who have suffered damage to receive fair compensation. Article 1 of this convention over the page sets out the purpose. Each party shall provide in its internal law for effective remedies for persons who have suffered damage as a result of acts of corruption, to enable them to defend their rights and interests, including the possibility of obtaining compensation for damage. There's then a definition of corruption in Article 2, and in Article 3, compensation for damage. Each party shall provide in its internal law for persons who have suffered damage as a result of corruption to have the right to initiate an action in order to obtain full compensation for such damage. Also of interest is Article 5, state responsibility. Each party shall provide in its internal law for appropriate procedures for persons who have suffered damage as a result of an act of corruption by its public officials in the exercise of their functions, to claim for compensation from the state, or in the case of a non-state party, and that party's appropriate authorities. My lords, there is more to that convention. I'm conscious that your lordships do not have the full version. With the assistance of your lordships associate, may I hand up? Thank you very much. 3 copies. Got the full version. And your lordship see there are other provisions, none of which I think are material, with the possible exception of Article 13. The parties shall cooperate effectively in matters relating to civil proceedings in cases of corruption, especially concerning the service of documents, obtaining evidence abroad, jurisdiction, recognition and enforcement of foreign judgments, litigation costs, in accordance with the provisions of relevant international instruments on international cooperation in civil and commercial matters to which they are party, as well as with their internal law. As I mentioned, the United Kingdom has signed this convention, but we've not ratified it. But it did enter into force on the 1st of November 2000, because sufficient parties did sign it. And in relation to a convention that we have signed but not ratified, I draw attention to the Vienna Convention on the Law of Treaties, the relevant provision of which is in volume 8 of the authorities at tab 49, page 2348. And the relevant provision is on page 2355, electronic 2355, article 18 of the Vienna Convention on the Law of Treaties, headed Obligation not to defeat the object and purpose of a treaty prior to its entry into force. And we're told a state is obliged to refrain from acts which would defeat the object and purpose of a treaty when A, it has signed the treaty or has exchanged instruments constituting the treaty subject to ratification, acceptance or approval, until it shall have made its intention clear not to become a party to the treaty. So we have those obligations, or that obligation, under Article 18, because we've signed the convention unless and until we've made our intention clear not to become a party to the treaty. And we can find no statement that His Majesty's government is not proposing at some stage to become a party to this treaty. In any event, we say it's an important statement of international law principle that it is entirely consistent with the other matters that your lordships have seen in relation to the public policy of this country. There are statements that the government was considering considering ratifying this treaty, but was not yet in a position to do so. We see that, just for completeness, in this supplementary authorities bundle that your lordships were looking at a few moments ago. And behind tab 1, your lordships will see the statement of the then Lord Chancellor, Lord Irvine of Legg, announcing that we had signed this civil law convention. The Lord Chancellor made comments as to its importance, but said that we were not yet in a position to ratify because of rules relating to limitation of actions, which the Law Commission was looking at. That was the position in 2000. In May 2003, which is the second tab, there was a parliamentary question to the Secretary of State for Foreign and Commonwealth Affairs, and the Minister, Mr. McShane, answered the question. And the question related to Council of Europe conventions, and over the page, on electronic page 4, your lordships will see item 13 is the Civil Law Convention on Corruption. And the answer given was that certain minor amendments are needed in relation to UK law on limitation of civil actions to enable ratification to take place. Relevant provisions have been included in the Corruption Bill, which was recently published in draft, which will be taken forward when a legislative opportunity rises. And we can't find any indication that there has been ratification, but equally no statement that the United Kingdom is not going to ratify. We also draw attention as the fourth document in this same bundle.
Did the Corruption Bill become the Bribery Act?
Yes, it did. Item 4 of the Supplementary Authorities bundle contains the United Kingdom Anti-Corruption Strategy for 27 to 2022, and this again demonstrates the policy of His Majesty's government, which is relevant to, although not coexistent with, the public policy that the court will apply. It's certainly relevant to, and it emphasises repeatedly the importance of taking steps to address corruption internationally. Just some highlights, my lords. On electronic page 21, the lordships will see at the top of the page priorities and goals, and priority 5 is reduced impact of corruption on trade and investment internationally, enhanced international development finance and export finance practices, strengthen business-led collective action to reduce corruption. And on page 10, which is page 22 of this document, we see in the left-hand column in the middle of the page our approaches, and the third of those is to pursue and punish the corrupt, strengthen the ability of law enforcement, criminal justice and oversight bodies to investigate, prosecute and sanction wrongdoers, which is criminal, and reduce the impact of corruption where it takes place, including redress from injustice caused by corruption. Then I draw attention to page 30, electronic page 30, where we're told on the left-hand column that tackling corruption is at the heart of the United Kingdom government's efforts to keep Britain safe, to preserve the prosperity we enjoy. It also underpins the rules-based international system and global prosperity, etc., etc. Then, to like effect, is page 34. In the left-hand column, your lordship see in the box, international frameworks. There's a quotation from the then Prime Minister. And then this, the fight against corruption is underpinned by international agreements and standards. The UK is strongly committed to implementing our commitments under the UN Convention, the OECD Convention, the Council of Europe's Group of States Against Corruption, GRECO, and that's the body that monitors the Civil Law Convention Against Corruption, Peer Review Mechanism and the Financial Action Task Force. Then we see, again, to like effect on page 40, in the left-hand column under approaches, at the bottom of the left-hand column, reduce the impact of corruption where it takes place, including redress from injustice caused by corruption. We will help those affected by corruption at home and abroad, for example, through supporting international processes for asset return and compensation, and we will support those who report corruption. So all of that informs the court in my submission as to the content of public policy, and all of that is of course of particular importance in relation to the sixth respondent in this case, CDC, which is a United Kingdom government entity which on the pleading has been heavily involved in the funding of the DFCU Bank. We say that these important public policy considerations, as set out by Lord Templeman, by the Bribery Act, as explained by Mr. Straw, by the UN Convention, by the Council of Europe Convention, Civil Law Convention, the statements, the review strategy document from His Majesty's government, all of that, and their recognition of the vice of international corruption and bribery would be substantially undermined by allowing defendants to escape liability, civil liability for corruption in the courts of this jurisdiction by reliance on the doctrine of foreign act of state. It would be contrary to public policy. Plainly, there are many differences between torture and corruption. But the essence of what Lord Sumption said in Belhadj does, we say, have very close analogies with corruption. Can I remind your lordships of what Lord Sumption...
Well, you presumably would say that the obligations imposed, for example, by Article 35 of the UN Convention would be rendered as naught if the Foreign Act of State doctrine were to apply in this case.
Yes.
And that's why you say, well, public policy requires that there is a cause of action, even if it's one against a foreign state entity or its officials.
Yes. I do so submit. I invite your lordships either to decide, or at the very least to say that the answer to that question may well depend, the application of public policy may well depend upon the particular circumstances of the case, the gravity of the wrongdoing, for example, and therefore, even if the court it takes the view it's inappropriate to decide the point, as it were, on the pleadings, the matter should be allowed to go to trial, not least because the allegations in this case, which we hope to establish at trial, are allegations of particularly egregious conduct by the relevant officials. And the allegations are of a scheme to destabilise an otherwise profitable bank by the use of regulatory powers. The central bank putting the banking system of Uganda at risk for the personal gain of the officials. I mean, that's the essence of the allegation. That's a remarkably serious allegation. And the more we can prove, the stronger the public policy argument for not allowing foreign act of state to stand in the way. And that's why I suggest to your lordships that it may take the view that it isn't necessary or appropriate to decide the point at this stage, but to recognise on the pleading that there is at least sufficient for this issue to be allowed to go to trial. That's how I put it.
In your submissions, you've focused on bribery to a large extent. I'm not quite clear how that fits in with the chronology and the different wrongs, the unlawful acts alleged. You say that everything you pleaded is tainted by and encompassed by the bribery allegation.
Yes, well, everything pleaded once the first respondent came on the scene. Yes, because there was already a scheme that this bank would be taken into statutory management.
But at that point, there was no bribery, was there? Is it anticipation of bribery?
Yes. Well, there was a.
But isn't it? But it's corruption.
Yes, it's corruption. Certainly, the corruption, at the very least, involved a scheme, the purpose and intention of which was to dispose of this entity to persons who would be prepared to pay bribes.
Well, it was originally going to be sold to a Chinese
Yes, yes.
entity.
And there's this individual who, on the pleadings, had received a bribe. I'm sorry, he paid a bribe. Yes, the Chinese, Dr. Ho, had paid a bribe, a very substantial bribe, and on the pleadings has been convicted in the United States courts for his actions. And on the pleadings, the scheme with the Chinese entity did not proceed because they got cold feet. That's the pleading. So there was a need to look for somebody else. And the first respondent came on the scene as a result of discussions with them. The bank, CBL, was taken into receivership, and the next day the assets were sold to the first respondent. That's the allegation, in return for very substantial bribes. Now, we say the position is analogous. It's not the same, but it is closely analogous to the observations of Lord Sumption in Bell Hadge. Can I take the court, please, back to Bell Hadge? It's tab number, Authorities Volume 4, and it's at tab 22. The paragraph I have in mind is paragraph 262 of His Lordship's judgment, which the court finds at page 1164 of the law report, page 1262 of the electronic bundle, and paragraph 262. Sumption says, in my opinion, it would be contrary to the fundamental requirements of justice administered by an English court to apply the Foreign Act of State doctrine to an allegation of civil liability for complicity in acts of torture by foreign states. Respect for the autonomy of foreign sovereign states, which is the chief rationale of the Foreign Act of State doctrine, cannot extend to their involvement in torture, we say bribery and corruption, because each of them is bound erga omnes, and along with the United Kingdom, to renounce it as an instrument of national or international policy and to participate in its suppression. The same is true of corruption and bribery. In those circumstances, the only point of treating torture by foreign states as an act of state would be to exonerate the defendants from liability for complicity. We say the same is true of bribery and corruption. Foreign states and the United Kingdom are bound to renounce corruption and bribery as an instrument of national or international policy and to participate in their suppression. Now, the judge below addressed the public policy exception, paragraphs 32 to 35 of his judgment. Again, the purpose of this exercise is not to criticise the judge, although his attention was directed to both the Bribery Act and the UN Convention by my friend Ms. Brown. And neither of those are addressed by the judge in the judgment at Core Bundle 5, pages 66 to 68. And picking it up at paragraph 32, the judge begins by saying the factual basis for the claimant's reliance on the exception is based on an assertion that it is English public policy to combat and not give legal protection to corrupt practices. And then at 33, no authority has been cited that suggests the existence of such a policy in this context. Well, as I've sought to explain, our answer to that is that the scope of the public policy exception is a developing concept, and there is no authority which determines one way or the other whether a public policy can extend, and in what circumstances, to combating bribery and corruption. I do not accept, and it cannot be right in principle, that the scope of the exception requires proof that there is some existing case that establishes this public policy. It is enough, as the authorities I cited yesterday afternoon indicate, for us to show a public policy by reference to statute, by reference to international material and other relevant material. The judge then says in the second sentence of paragraph 33 that to date public policy has only been engaged in relation to grave infringements of fundamental human rights and breach of a group of international legal norms, the common feature of which is that they are accepted as binding by all states. I accept this is a category of norms that by its nature will change or develop over time. However, it is necessary to note the very confined nature of the rights concerned. And then there's a reference to the Kuwait authorities case, and there's a reference to UCOS dealing with expropriation. And that chimes, of course, with the observations of my Lord the Chancellor that we looked at yesterday in the Koza case. Our argument is not to dispute the need to show something exceptional, something very grave. Our case is that corruption and bribery are matters of the gravest concern to the international community and indeed to this community in this country. We also draw attention to the fact that the nature, as the judge himself accepted at the top of page 67, the nature of the mischiefs, the wrongs that can attract the public policy exception is a developing concept. And can I remind your lordships of one other authority, recent authority, which demonstrates that there may be new exceptions to the FAS doctrine. The case is the Al Maktoum case, which is Authorities Volume 5, tab 28. This is one of the many judgments of the courts in relation to the unhappy dispute between Sheikh Maktoum and his former wife, Princess Haya, at least one of which came before the court of my Lord the Chancellor. I think it was on the facts. I think your lordship decided whether or not there could be leave to appeal and granted leave to appeal and then dismissed the substantive appeal on the factual findings. This one was an earlier one concerning foreign act of state, and it's a judgment of the Master of the Rolls, Geoffrey Voss, sitting with Lord Justice Moylan and Lady Justice Andrews, and the allegations that the court was considering are set out at page 1595 of the electronic bundle. And the court sees the allegations were that the father, Sheikh Maktoum, had hacked or had arranged for the hacking of the mobile telephones of the mother, her solicitors, her personal assistant, and 2 members of her security staff. The surveillance was carried out using software licensed to Dubai or the UAE. The surveillance was carried out by the agents of the father, Dubai or the UAE, and the software used included the capacity to track the target's location, and the surveillance occurred with the express or implied authority of the father. So that was the allegation. A breach of human rights on the allegation, certainly, but not of the level of gravity of the Nazi laws considered in Oppenheim, or torture, or I would suggest hijacking of an aircraft. And the argument that was advanced on behalf of the father, see paragraph 3, was that the court should not consider these allegations because of a rule of foreign act of state. And the relevant rule is set out at paragraph 29. It was Lord Newburger's third rule, and the father sought to bring himself within that third rule, a challenge to the lawfulness of the act of a foreign state which is of such a nature that a municipal judge cannot or ought not rule on it. And the court sees at paragraph 26 that the High Court, it was the President of the Family Division sitting with Mr. Justice Chamberlain, paragraph 26, the High Court decided that the FAS doctrine was not engaged for the reasons there set out. And at 27, finally the High Court decided that if, contrary to its view, Lord Newburger's third rule applied, the 5 matters it had relied upon to decide that the FAS doctrine was not engaged would together justify the engagement of the public policy exception. And the Court of Appeal agreed. We see that at paragraph 42, where the Court of Appeals, Geoffrey Voss speaking for the court, says that the FAS doctrine was not engaged. And then at, over the page, electronic 1602, issue 3, paragraph 43, this issue does not arise, but we agree with the High Court. In the circumstances of this case, it raises precisely the same questions as arose in relation to the engagement of the doctrine, and they accepted, the court accepted that the exception, the public policy exception, would apply if it were needed, and that demonstrates the developing nature of the public policy exception. Going back to the judgment below, I've read relevant parts of paragraph 33. Paragraph 34 at the top of page 68, the judge said, no rule of international law relevant to corruption has been identified as triggering the exception I'm now considering, much less one that can be said to engage English public policy. Well, I've made my submissions. There is a clear rule of international law in the UN Convention Against Corruption, supported by the Council of Europe Convention. But in any event, as was made clear in the Belhaj case, it's not necessary for an exception to apply to demonstrate that international law so requires. That isn't, it's a domestic policy, not an international policy. And then there's a reference to other cases.
Do we get anything from Federal Republic of Nigeria?
It's in the authorities. I wasn't proposing to take your lordships to it because it's a very brief observation.
Sort of tentative observation, yes. Passing, really, isn't it?
It is, my lord. It's not based on any of the authorities that I've drawn attention to. Your lordships will have seen it, but it's at least a recognition that the judge in that case, Mr. Justice Cockerell, did not regard the point as one that should be disposed of in limine. And in my submission, for all the reasons I've sought to advance, that is correct.
You focused on the question of corruption as the policy, but in civil law terms, bribery is one of 2 aspects of the tort of fraud.
Yes.
And we have a lot of policies about fraud.
Yes.
So, but you don't say that you don't rely upon a policy that fraud unravels all, and this court will not stand by and see effectively allow fraud to go unrecognised.
Fraud, of course, is a very serious mischief, but bribery and corruption are on the authorities in the international documents that I've shown the court of international concern, of public policy concern to a far greater degree. There may be circumstances where fraud of itself, with no element of bribery and corruption, could establish a public policy exception. If, for example, someone was suing a foreign entity and a foreign act of state were raised in relation to a fraud claim. So I wouldn't wish to rule out that possibility, but I do submit that the elements of bribery and corruption are so damaging to civil society and to the rule of law that they have been recognised as such by these international conventions, that it's much easier in relation to bribery and corruption to satisfy the court either that there is a public policy exception, or at the very least that it's properly arguable that there is and the matter should go to trial. That's how I would put it. My friends in their skeleton arguments have taken other points. They've drawn attention to the fact that judicial review can be claimed against the unlawful acts of the BOU in Uganda. We do not accept the possibility of a judicial review application in Uganda has any relevance to the application of the public policy exception to the FAS doctrine. There's no forum conveniens challenge by the respondents. We're simply dealing with the scope of the FAS doctrine. And if it were to matter, a judicial review application would not provide a remedy in damages in Uganda, just as it could not in this country. My friends also draw attention to the fact that other issues arising out of CBL's experience have been litigated before the Ugandan courts, and that's summarised in the amended particulars of claim, paragraphs 8G to 8HD at pages 96 to 98 of Core Bundle 7. And your lordships have seen it was litigation relating to the end of the receivership and what were found to be illegal acts by the BOU in purporting to place CBL thereafter into liquidation. And the Ugandan Supreme Court, as I mentioned yesterday, ruled that the management of the first claimant reverted to the shareholders after the 20th of January 2018. None of this assists my friends in my submission. They also point out that in any event, public policy needs to be balanced against other factors, and there does remain some uncertainty about the principles of law applicable in this respect. This was discussed by Mr. Justice Marcus Smith in the Pakistan case, High Commissioner for Pakistan and JAR, which the court will find in volume 5 of the authorities at tab 25. And in a very comprehensive judgment, this point appears at page 543 of the law report, tab 25, page 1521 of the electronic bundle.
Give me the page number again.
Yes, 543 of the law report, paragraph 312, where his lordship said what is clear is that even if Rule 3 is engaged, there is a public policy exception. Quite how this exception works is a matter yet to be explored. It may be that the exception involves a balancing exercise whereby a strong engagement of Rule 3 can defeat a weak public policy exception, which is very much what the Court of Appeal's approach in Lord's Bench and Trust, the Ukraine case, appears to suggest, of course, the Supreme Court not addressing that matter because they were satisfied that Kirkpatrick exemption applies. Or it may be that when once Rule 3 is engaged, the question of non-justiciability is a given that can only be offset by some form of public interest exception, which once established does not need to be weighed in the balance. There's something to be said for either approach. Now, this is not a matter that arises in the present case. My submission to your lordships is that this question of balance, if any, is not a matter, it's not an appropriate subject for determination on a strikeout basis. It's a matter for determination in the light of the facts found at trial. If your lordships were to wish to consider balancing factors and the weight of the public policy in this case, it would be our submission that any balancing exercise should come down firmly in favour of applying the public policy exception in the circumstances of this case. And the reasons for that are that the public policy that I've sought to identify against bribery and corruption is directly engaged and engaged in a case on the pleadings, which we say is particularly egregious. And I made that point earlier in answer to my Lord the Chancellor. Second, we point out that this case is not concerned on the pleadings with any act conducted on behalf of a state for policy reasons or in the interests of the state. We're here concerned on our case with wrongdoing by the defendants who bribed the state officials who were acting purely in their own personal interests. And the state funds were misappropriated, were laundered. And this is one of the vices of corruption. It's a point, incidentally, which was drawn attention to by Lord Justice Mayles when he granted permission to appeal, as the court may have seen at Core Bundle 8, tab 8. It's page 152. His Lordship giving permission to appeal in his reasons at the top of the page. Reason 2. It's tab 8, my lord, page 152. Further, the application of the Foreign Act of State principle to a case involving the corrupt misuse of executive powers for private gain merits consideration by this court. So that's the second point. And the reason why that's important is because the purpose of the FAS doctrine, as the court has seen, is to promote comity in interstate relations. That's what Lord Lloyd Jones said in Maduro, paragraph 135. So the fact that these claims do not impugn any policy of the state reduces, if not extinguishes, any potential threat to comity. And thirdly, there are other reasons why comity is not endangered by a public policy exception applying. And not only that Uganda itself has ratified the UN Convention, it is also that in this case, on the pleadings, the Ugandan courts and other public institutions have already themselves expressed grave concerns about the conduct of the BOU officials in various respects relating to the claimants. And we've set this out in our re-amended particulars of claim, paragraphs 8G to 8HD, the decision of the Supreme Court criticising the decision put the company into, to put the bank into liquidation. And as the court will have seen, a parliamentary committee in Uganda has expressed grave concerns about the conduct of the BOU officials. That's supplementary bundle 2, tab 14, which contains the report of the Committee of Commissioned Statutory Authorities and State Enterprises on the special audit report of the Auditor General. And that contains, I'm not going to take time on it unless the court wants me to, but it contains a number of very serious criticisms of the BOU conduct in this context. So all of that undermines, in my submission, any suggestion that could be made that for the courts to hear this trial would damage validity. And a further point on balance is one I've already made, that DFCU was owned, is owned by foreign investors. That's the 6th to 9th defendants. And the 6th defendant, as I mentioned, it's paragraph 6 of our re-amended particulars of claim, is the CDC Group, now known as British International Investment PLC, wholly owned by the UK government. For the reasons I've given, we do respectfully suggest that this is a matter of some importance, that if the judge below and my friends are correct, corruption, bribery and corruption, however egregious, cannot engage the public policy exception as a matter of principle. And it would mean that all or the substantial majority of civil claims alleging corruption of foreign officials would be barred from the courts of this jurisdiction. We say that would be wrong in principle, but it would also be anomalous because it would mean that in some cases a prosecution under the 2010 Bribery Act would be possible, but a civil claim would be barred. We therefore submit that either the court should accept that the public policy exception applies in the circumstances of this case on the pleaded facts, or at the very least that it is inappropriate for allegations of this sort, the application of the public policy exception to be struck out and not allowed to go to trial. Yep. That's our case on public policy.
Is that a convenient moment to take a break?
Very convenient.
Don't even find it.
Go, Rice.
It's more attractive just to see. It's a strong. Okay, so I've just got. Yes, yeah, I don't care how much, but it's expensive.
You still thinks that fundamental state is a substantive. No. That's the problem. And I do think that three or four to access. Sure, it makes a difference. But the thing is, we can't find judicial cases upon which to decide close to being substantive. We're simply not going to find it. Which I think maybe the main consideration. Okay.
Four eyes.
My Lord, the final point is Article 6 of the European Convention on Human Rights. The application of Article 6 was analysed by Lord Sumption for the Supreme Court in the Bank of Uganda case. Can I take your Lordship's please to Volume 5 of the Authorities, tab 23. This was a sovereign immunity case. Article 6 was set out by Lord Sumption at page 798 of the law report, page 1292 of the electronic bundle, paragraph 14, letter F on page 798. Your Lordship see Article 6 and the determination of his civil rights and or obligations. Everyone is entitled to a fair and public hearing. The assumption then says 2 points are well established and uncontroversial. The first is that Article 6 implicitly confers a right of access to a court to determine a dispute and not just a right to have it tried fairly. There's some authority for that. The second uncontroversial point is that although there is no express qualification to a litigant's rights under Article 6, except in relation to the public character of the hearing, the right to a court is not absolute under the Convention any more than it is a common law. It is an aspect of the rule of law which may justify restrictions if they pursue a legitimate objective by proportionate means and do not impair the essence of the claimant's right. And then this at 15, one of the perennial problems posed by the right to a court is that Article 6 is concerned with the judicial processes of convention states and not with the content of their substantive law. And there's some authority, the James case, the Fired case, and just above D, it is not always easy to distinguish between cases in which the petitioner's problem arose from some difficulty in accessing the adjudicative jurisdiction of the court, in which case Article 6 does apply, and cases where it arose from the rules of law which failed to be applied when he got there, in which case Article 6 does not apply. The jurisprudence of the court establishes that as a general rule, the question whether such cases amount to the creation of immunities engaging Article 6 depends on whether the rule which prevents the litigant from succeeding is procedural or substantive. And the authorities are cited, including Roche and Markovich, to which I'm going to come. 16, the dichotomy between procedural and substantive rules is not always as straightforward as it sounds, partly because the categories are not wholly distinct and partly because they do not exhaust the field. There may be rules of law, such as limitation, which are procedural in the sense that they bar the remedy, not the right, but which operate as defence. There may be rules of law which require proceedings to be dismissed without consideration of the merits. These may be substantive rules, such as the Foreign Act of State doctrine, or procedural rules such as state immunity. So I accept the assumption is categorising, certainly for the purposes of domestic law, he's categorising, Lordship's categorising Foreign Act of State as a substantive rule. And then he gives further examples. And then 6 lines up from the end of the page is the important word, but these are not refinements with which the Strasbourg court has traditionally been concerned. What the Strasbourg court means by a procedural rule is a rule which, whether technically procedural or substantive in character, has the effect of barring a claim for reasons which do not go to its legal merits. That is to say, rules which do not define the existence or extent of any legal obligation. So for Lord Sumption, speaking on behalf of the court, that is the Strasbourg law test. And our case, and I'll deal with the authorities in a moment, but our case is that the Foreign Act of State doctrine, the FAS doctrine, does not bar a claim for reasons which go to its legal merits. It bars a claim for reasons which do not go to its legal merits. The legal merits of our claim are irrelevant to the application of FAS, we are assuming for the purposes of this appeal that we have a very good legal claim on the merits. FAS, therefore, I submit, is a procedural rule, and therefore Article 6 applies. However, I accept that was not the view of Lord Mance and Lord Sumption Obiter, certainly Lord Mance Obiter, in the Belhadge case. The judge below pointed out, it was paragraph 38 of his judgment, that Benkabuch is a case about state immunity. It's not a case about the FAS doctrine. And I say the relevance of Benkabuch is in the statement of principle by Lord Sumption at paragraph 16 and paragraph 15 for identifying whether a rule is in Strasbourg terms procedural or substantive. If it's substantive, it falls outside Article 6. If it's procedural in Strasbourg terms, it falls within Article 6, and the distinction, the difference, is defined by the assumption at the end of paragraph 16 of Benkabuch. That's the relevance of Benkabuch. I have to accept that that wasn't what Lord Sumption and Lord Mance thought in Belhadge was the application of this procedural substantive rule to foreign act of state. Belhadge is in volume 4, tab 22, electronic bundle 1062. Lord Mance deals with the matter at page 1160. Lord Mance at paragraph 11.5b, which is, yes, it's page 1062 of the law report, and it's page 1160 of the electronic bundle. And Lord Mance at Roman 5 at letter C on page 1062 of the law report says it is unnecessary to reach any final determination of the respondent's case, and then he's got A, so this is obiter, and at letter F, yes, and B begins between letters D and E, that Article 6 of the Convention Rights is engaged by and renders impermissible in the present circumstances any reliance on either state immunity or foreign act of state. So he's recognising this is obiter. It's unnecessary to decide the point. And he then says at F, foreign act of state, on the other hand, operates even under the case law of the European Court as a substantive bar to liability or jurisdiction, and he cites two cases to which I'll come, Roche and Markovich, and so would not, if applicable, engage Article 6. Even if Article 6 were engaged, the question would then have arisen whether it rendered impermissible any reliance on either state immunity or foreign act of state. But since I would hold that appellants cannot rely on either in any event, it's unnecessary to go further into this. And his lordship repeated the substance of that later in his judgment at paragraphs 110 and 11, which your lordships will find in the law report at page 1109 and in the electronic bundle at page 1207. So 1109 of the law report, at the bottom of the page, paragraph 110, as regards foreign act of state, the question would have been whether for similar reasons Article 6 was or was not engaged. Foreign act of state operates even under the case law of the European Court as a substantive bar to liability or adjudication. See Roach and Markovich. On this basis, foreign act of state, even if it had otherwise been applicable, would not engage Article 6. If Article 6 was engaged, the question would then have arisen whether it rendered impermissible any reliance on either state immunity or foreign act of state. But in view of what I've already decided, it's unnecessary to go further into this. So that was the view of Lord Mance. The only other of the 7 judges on the Supreme Court who addressed this question was Lord Sumption. Lord Newburger did not address this point. Lord Sumption, with whom Lord Hughes agreed, addressed the Article 6 issue at paragraphs 282 and following. That's at page 1171 of the law report, page 1269 of the electronic bundle. So page 1171 of the law report, paragraph 282. Lord Sumption says at 282, Article 6 might in principle apply so far as the application of the Foreign Act of State doctrine would constitute a denial of the claimant's right to a court. And then there's lots of authority. And at H, he says, but except in rare cases where there's no judicial or manageable standards by which to determine an issue, the Foreign Act of State doctrine is not an immunity. It is a rule of substantive law, which operates as a limitation on the subject matter jurisdiction of the English court. Then he refers to Roach. He says the European Court held the right to a court protected by Article 6 was not engaged by a substantive rule of domestic law excluding liability, but only by a bar which was procedural in nature. And then at 283, he says the most personal illustration is Markovich. The applicants in this case were relatives of persons who'd been killed in the NATO air raid on Belgrade in 1999. The raid was said to be an act of war in violation of international law. It had been launched from bases in Italy. The Cassation Court had held that by a rule of substantive law, the Italian courts had no jurisdiction over acts of war or indeed over any acts of the Italian state which were impugned on the sole ground that they violated international law. The Strasbourg court applied the distinction between substance and procedure that they formulated in Roach. They agreed that the limitation on the jurisdiction of the Italian court was substantive. It followed that the decision of the Cassation Court does not amount to recognition of immunity, merely indicative of the extent of the court's powers of review of acts of foreign policy, such as acts of war. 284, to the limited extent that any foreign act of state doctrine might apply in these cases, it does not, in his lordship's opinion, engage Article 6. Now, none of that is binding. It's obviously very highly persuasive authority. It is my submission, with the greatest of respect, that Homer nodded in that case. I should also draw attention to the fact that in the Court of Appeal in Belhadj, the 3 judges formed a different view for different reasons. The Court of Appeal judgment of Lord Dyson, Master of the Rolls, Lord Lloyd Jones and Lady Sharp can be found at page 1027 of the law report, in the same tab, 1027, page 1125 of the electronic bundle. And at paragraph 122 on page 1027, the Court of Appeal said, so far this discussion has proceeded entirely by reference to the common law. It's also necessary to consider whether Article 6 has any application. And at 123, there's the court then analyses the doctrine of act of state, and the relevant part, I think, is the last 5 lines, where they say, however, having regard to the particular circumstances of this case, we do not consider that the act of state doctrine is here capable of outweighing the claimant's Article 6 right of access to the court. In coming to this conclusion, we've had regard to all the considerations set out above which have led us to the same conclusion on our analysis of the position of common law. So that's a finding by the Court of Appeal, but Lord Mance and Lord Sumption take a different view. And the reason they take a different view was based on the two judgments of the European Court that are mentioned. The first of them is Markovich, which is Authorities Volume 7 at tab 37. As your lordships have seen from Lord Sumption's judgment in Belhaj, this was a claim based on the NATO bombing of Belgrade, launched from bases in Italy. And the complaint in the Italian courts was that this was an act of war in violation of international law. And the Italian courts held that they had no jurisdiction to deal with such allegations. Why? Well, because the alleged wrong did not confer any domestic law rights. And we see that in the judgment, paragraph 18, which is on page 1051, 1051 of the law report, and page 2150 of the electronic bundle. Paragraph 18 of the European Court's decision sets out what the Court of Cassation, sitting as a full court, found. They found the Italian courts had no jurisdiction. It reasoned as follows. 2. The claim seeks to impute liabilities to the Italian state on the basis of an act of war, particular conduct of hostilities through aerial warfare. The choice of the means that will be used to conduct hostilities is an act of government. These are acts through which political functions are performed, and the Constitution provides for them to be assigned to a constitutional body. The nature of such functions precludes any claim to a protected interest in relation to. And then a bit more, and then with respect to acts of this type, no court has the power to review the manner in which the function was performed. Then there's a reference to the provisions of international agreements, and in the penultimate paragraph, however, the legislation implementing these rules in the Italian state does not contain any express provision enabling injured parties to seek reparation from the state for damage sustained as a result of a violation of the rules of international law. So that was the basis of the Italian court's findings. You simply have no rights in Italian law. And the European Court, by a majority of 10-7, held that there was no breach of Article 6 because the applicants did not have domestic law rights. And we see this in the reasoning of the European Court at page 1079, electronic 2178, and paragraph 111. The European Court says, consequently, it's not possible to conclude from the manner in which the domestic law was interpreted or the relevant international treaties were applied in domestic law that a right to reparation under the law of tort existed in such circumstances. 112, the court also notes that the Court of Cassation has already ruled in an earlier case that the Italian courts had no jurisdiction over the authorities for acts of a political nature, and that such acts did not give rise to a cause of action against the state because they did not damage personal legal interests, which were the only interests capable of affording a right to compensation under the domestic case law. Indeed, it was after the hearing before it that the Court of Cassation provided clarification as to what constituted an arguable claim in law. Determining the limits of its jurisdiction, the Court of Cassation marked out the bounds of the law of tort, etc., etc. 114, the court considers the Court of Cassation's ruling in the present case does not amount to recognition of an immunity, but is merely indicative of the extent of the court's powers of review of acts of foreign policy, such as acts of war. it comes to the conclusion the applicant's inability to sue the state was the result not of an immunity, but of the principles governing the substantive right of action in domestic law. And at the relevant time, the position under the domestic case law was such as to exclude, in this type of case, any possibility of the state being held liable. So that is a case, we say, by contrast with the present, where the claimant simply had no civil law rights under domestic law. And that's why Article 6 did not apply. Their complaint was about the substantive content of Italian domestic law. By contrast, in the present case, on the pleadings, the claimants do have substantive causes of action against the defendants under Ugandan law, which is the applicable law. And the effect of applying the FAS doctrine in the present case is procedural, not substantive, applying Lord Sumption's distinction in Benkabush at the end of paragraph 16. That is a rule which, whether technically procedural or substantive in character, has the effect of barring a claim for reasons which do not go to its legal merits. So Markovich does not assist the case against us for those reasons. Cannot bear the weight which, with respect, which Lord Sumption and Lord Mance attributed to it. The other authority on which they rely is Roche, and Roche appears in the preceding tab 36 of volume 7, and this is a United Kingdom case, Roche against the United Kingdom. And this was a case where the claimant alleged that his Article 6 rights had been breached because the Secretary of State had issued a certificate under Section 10 of the Crown Proceedings Act 1947. As your lordships will know, that section, Section 10, provides that members of the armed forces could not sue the Crown in tort if the Secretary of State issues a certificate saying that their injuries were sustained in the course of their duties. They're left to bring claims under various schemes that the Secretary of State has set up. So the complaint was the application of the certificate is a breach of Article 6, excludes us from court. And the European Court rejected that challenge. They rejected the Article 6 challenge, albeit only by 9 votes to 8. And at paragraph 119 of the judgment of the European Court, which is on page 634 of the law report, page 2118 of the electronic bundle, the court refers to the procedural substantive distinction. At paragraph 119, some 5 lines down, they say, and in particular, in the light of the court's affirmation as to the necessity to maintain the procedural substantive distinction, fine as it may be in a particular case, this distinction remains determinative of the applicability and, as appropriate, the scope of the guarantees of Article 6. In both these respects, the court would reiterate the fundamental principle that Article 6 does not itself guarantee any particular content of substantive law of the contracting parties. And the application of that principle to the present case, to that case, appears at paragraph 122 on the next page. And the court says it's taken as its starting point the assessment of and the conclusions concerning Section 10 by the House of Lords, by the Appellate Committee, in the Matthews case. And drawing on the historical context, the text and purpose of the Act, the House of Lords concluded that Section 10 did not intend to confer on servicemen any substantive right to claim damages against the Crown, but rather had maintained the existing and undisputed absence of liability in tort of the Crown to servicemen in the circumstances covered by that section. And there's some detail, and at the end of paragraph 122, the final sentence, Section 10 was found therefore to be a provision of substantive law which delimited the rights of servicemen as regards damages claims against the Crown, and which provided instead, as a matter of substantive law, a no-fault pension scheme for injuries sustained in the course of service. And then finally, at paragraph 124 over the page, the European Court said it had no reason to differ from the unanimous conclusion of the Court of Appeal in the House of Lords as to the effect of Section 10 in domestic law. It considers that the impugned restriction flowed from the applicable principles governing the substantive rights of action in domestic law. In such circumstances, the applicant had no civil right recognised under domestic law which would attract the application of Article 6.1 of the Convention. It's not therefore necessary also to examine the parties' submissions as to the proportionality of that restriction. So I say, again, Roche is a case where, as a matter of domestic law, there was no substantive right to compensation for the alleged wrong. Domestic law conferred no substantive rights. And that's why the European Court said Article 6 did not apply, because it was a substantive restriction, not a procedural restriction. Neither of those cases helps, in my respectful submission, in relation to the present context and foreign act of state, because in the present case, by contrast with both Markovich and Roche, it is central to the proceedings and not in dispute, certainly at this stage of the proceedings, that the claimants do have substantive rights against the defendants under the applicable law, Ugandan law, which is being applied by the English court. And the foreign act of state doctrine, if applied by the courts of this jurisdiction, if we're wrong on public policy, we're wrong on commercial, not sovereign, we're wrong on Kirkpatrick. If the courts here apply the foreign act of state doctrine, they are doing so not in relation to the absence of, not in relation to reasons which go to the legal merits, the substantive merits of the claim in Ugandan law, but for extraneous reasons. And that is a prima facie breach of Article 6. We are being excluded from having our claim, our substantive claim, which is otherwise a good claim, determined by the court for reasons which are not based on the legal merits of the claim. See Benkabush, the dividing line in convention law stated by Lord Sumption at paragraph 16. I say prima facie breach because, as is recognised in Roche at paragraph 124, one then needs to move on to proportionality. And I again don't suggest that this court would wish to assess proportionality at this stage. If I'm right that there is at least a tenable basis for arguing that Article 6 applies, the trial court will have to balance all the relevant considerations. But the factors to which I drew attention in relation to public policy and balancing would be equally applicable in relation to Article 6. And indeed, I would say it would be it would not be easy for my friends to show proportionality in a context where the application of foreign act of state defeats the very essence of the right to have your case heard in a court. So that's our argument on the fourth and final point, Article 6. I recognise, of course, that what I'm submitting is in conflict with what both Lord Mance and Lord Sumption said in Belhaj, but for the reasons I've given the greatest of respect, I say that their reasoning is wrong, and the matter should go to trial.
What is left of the Act of State doctrine, if you're right?
If I'm right, then the application of the Act of State doctrine will depend upon proportionality, and there may be cases where it's appropriate to apply Act of State. For example, where the claim, although within the scope of Article 6, it's proportionate for the courts to say that they're not going to consider claims for reasons of comity, where, for example, the claim attacks a policy or legislation of a friendly state. And it may well be appropriate to apply for an Act of State in some such circumstances.
And yet we only very recently in the Supreme Court has outlined the Act of State doctrine, as you've taken us to, in Lord Lloyd Jones's judgment, in which he seems to regard it as a matter of the substantive jurisdiction of the court.
Well,
so he's wrong about that.
Well, he's wrong about it applying the European Convention test, yes, with greatest of respect. He wasn't considering Article 6. He wasn't looking at the authorities that are addressed.
He says in express terms, it is an exclusionary rule limiting the power of the court to decide certain issues.
Well, it is. Undoubtedly, that is undoubtedly correct. That is an accurate description of the Act of State doctrine. The question, however, is on which side of the line does the Act of State doctrine, is the Act of State doctrine to be applied in relation to the Bank of Uganda test? Can I take your lordship back to tab 23 of volume 5 and what is said there for the Supreme Court by Lord Sumption at paragraph 16. And Lord Sumption as well, I've read this to your lordship, between F and G, Lord Sumption regards the Foreign Act of State doctrine as a substantive rule. That's what he says.
Page?
Page 799 of the law report, page 1293 of the electronic bundle. This is paragraph 16 of Bank of Uganda. Lord Sumption for the Supreme Court, between F and G, just above G, he says these may be substantive rules such as the Foreign Act of State doctrine, which chimes with what your lordship is putting to me from Lord Lloyd Jones. But then if the court goes down 8 lines, we see that Lord Sumption says, but these are not refinements with which the Strasbourg court has traditionally been concerned. What the Strasbourg court means by a procedural rule is a rule which, whether technically procedural or substantive in character, so he's recognising it may be technically substantive, has the effect of barring a claim for reasons which do not go to its legal merits. That is to say, rules which do not define the existence or extent of any legal obligation. And the Act of State doctrine is not going to bar our claim for reasons which go to the legal merits of the claim. The legal merits of the claim are not in issue. And their rules, the Act of State rule does not define the extent or the existence of any legal
Well, we
obligation.
know that's not what
But
Lord's assumption.
But if that's right, as my lord put to you a moment ago, then wherever you've got a sufficiently arguable case, it would be a breach of Article 6, wouldn't it? For the Act of State doctrine to come into effect.
But Article 6 has two elements. The first element is, does it apply, which is the procedural substantive distinction. And if I'm right that Act of State doctrine is procedural, there's a second element, which is that there's only a breach of Article 6 if it is proportionate to deny access. And I'm recognising that there may be cases where it is consistent with Article 6 to apply the Act of State doctrine because it's proportionate to do so. This is not such a case, but there may well be cases where the Act of State doctrine centrally is applicable and it's proportionate for it to be applied because it relates, for example, to state policies or state legislation. But this is not such a case.
Well, it is slightly odd that Article 6 just doesn't feature. And it may be that one explanation might be that the exceptions were regarded as covering the whole territory in which it would be disproportionate, so that unless one comes within one of the identified exceptions, the Act of State doctrine itself is sufficient to make the Article 6 bar a proportional one.
Yes, well, one could reconcile it in that way. That's certainly not the approach that one sees in Belhadj. And again, it's not, in my respectful submission, a matter that should be determined by this court. It should be allowed to go to trial. If the public policy is sought to go to trial, I respectfully submit for the reasons I've given. This is an arguable point, at least an arguable point as well. But I recognise the difficulties. Of course, what I'm submitting to your lordships is contrary to the opinion. It's not the judgment, it's the opinion of Lord Mance. It's contrary to the judgment of Lord Sumption. But I've submitted, most respectfully, that they're wrong. The cases on which they rely, Markovich and Roche, simply do not support the proposition. That's how I put it. And that's the fourth of our 4 points. Unless there are other matters, my lords, we've given thought overnight to the question posed yesterday afternoon by my Lord Justice Phillips as to why we've not pleaded, whether we should plead the tort of bribery. We have pleaded the fact of DFCU's bribery of the BOU as a basis for the unlawful means conspiracy claim. That's paragraph 69G and M of the amended particulars of claim. This appeal is solely about FAS, and we are not submitting to this court that the FAS, the application of the FAS doctrine, the analysis, would change depending on whether we plead a standalone claim of bribery. So I'm not asking the court to allow any amendment in that respect. But we're very grateful to your lordship for raising the point. But that's our position. Unless I can seek to assist furthermore, those are the submissions I wanted to make. I've done slightly better than my estimate in timing terms. Thank you very much, Francis.
My lords, ground one is not pursued by the appellants, at least not in the form set out in the grounds of appeal in their skeleton, but has become a subsidiary, rather smaller argument to ground 3, public policy. So I will deal with that when I deal with public policy. Turning immediately to ground 2, Sovereign Act, and ground 4, Malone and Friends' submissions yesterday were remarkable, if you'll forgive me for saying so, and I mean that in the literal sense of prompting remark, for the fact that they did not, at the outset, or even really in the way he developed the arguments, actually address these 2 issues, his grounds of appeal in relation to Sovereign Act and Kirkpatrick, by reference to his client's pleaded case. Indeed, it took questions from each of my lords on different aspects to halt Malone and Friends' always elegant flow to question exactly what claim he was addressing. It was somewhat surprising to hear what were almost Malone and Friends' first words in opening the appeal as follows, transcript page 2. The issue on the appeal, as your lordships will have seen, is a very precise issue. It is whether, as Judge Pelling held, the claimants are unable to pursue their claims of bribery by the respondents because of the Foreign Act of State doctrine, FAS. Well, that isn't the issue on appeal. It isn't what His Honour Judge Pelling held, and the claimants do not and have not sought to pursue, quotes, claims of bribery, if by that is intended to describe the causes of action advanced in the re-amended claim form and the very detailed, very long amended particulars of claim. Those causes of action pleaded are, as my Lord Justice Popplewell pointed out to my friend, claims in unlawful means conspiracy, dishonest assistance, and knowing receipt, all made under and only under Ugandan law. And as my Lord Justice Phillips pointed out to my learned friend, not a claim for the tort of bribery. I would parenthetically add that there is no claim for the tort of bribery in the pleading, which would have to be under Ugandan law, because the claimant's case is that all their claims are made under Ugandan law and must be governed in all respects by Ugandan law. And of course, your lordships do not know if under Ugandan law there is a separately recognised tort of bribery.
Well, we know there's a crime because that's pleaded the Section 5A of the Anti-Corruption Act.
Lord, yes.
But
Lord, yes.
what we don't know is whether there's a separate tortious liability.
Well, and my Lord, it can be inferred from the very considerable lengths to which the claimants have already had to go to get their Ugandan law pleading to the state you find it in, that they do not, as well advised as they are, think or thought or now that it is a pleadable cause of action under Ugandan law. Otherwise, no doubt it would have been there. It was interesting that my own friend concluded his submissions by suggesting that this point was only being thought about last night, which I suspect can't be correct in view of the very great consideration that has been given by the claimants to their pleaded case. Now, my lords, I'll come back to the fact later, as you will have appreciated, that the slender, and we say very fragile, allegation that the first defendant paid a bribe to the BOU by transferring a book of bad debts with a face value of 100 million Ugandan shillings, that's about $27 million, came into the pleading in subparagraph 69M, that Malone Friend is, of course, very keen to treat as though it was the only thing in the 61-page amended particulars of claim. That came in by amendment in May 2022 as part of the claimant's attempts to shore up their claim in the face of questions being raised by all defendants about the legal viability of the claims as against the defendants. But it is quite wrong to characterise the claims advanced in these proceedings, as my own friend did, as their claims of bribery by the respondents. It is no such thing. It was no such thing when the particulars of claim were in unamended form, and the addition of subparagraph 69M did not transform the claims. The proof of that pudding being in the reading of the pleadings. First, the particularised causes of action did not change after amendment. Indeed, somewhat amusingly, I noted last night on looking at it again that there was a change by amendment in that the headings of the sections addressing the causes of action, namely the heading unlawful means conspiracy above paragraph 68, the heading dishonest assistance above paragraph 85, and the heading knowing receipt above paragraph 89 were amended to put them in bold font. They had previously been underlined. That is an emphasis which was rather on the cause of action, rather absent from the argument yesterday. The second proof of the point that the addition of subparagraph 69M did not change in any respect the causes of action advanced is that the claim form was not materially amended as a result of or consequent upon the amendments to the particulars of claim. The re-amended claim form is at core bundle tab 7,
Yeah.
bundle page 83, and you will see that the amendments, the amendment and re-amendment are not material. The amendment, the tweaking of paragraph 1 in relation to the shareholding of the second to seventh claimants, and the re-amendment, paragraph 12, the addition of a statement as to value. And no amendment was made to the claim form following the series of amendments which included subparagraph 69M, and rightly so. The amendments to the particulars of claim did not change the causes of action, and so there was no need to amend the claim form in that respect. And, as was pointed out to my own friend yesterday, the claim form does not refer to alleged bribes by the respondents, let alone formulate a claim for bribery. As I say,
It's unlawful means conspiracy at paragraph 6, dishonest assistant
paragraph 7,
at 7, and then constructive trust.
knowing receipt, para 9.
Yeah.
Lord, again, it's worth pausing to consider the significance of the basis of all the arguments your Lordship heard yesterday. This is relevant to ground 2, ground 4, and to ground 3 public policy. That those arguments were addressed in relation to what were being described as the claimant's claims in a claim form which does not refer to bribery, an allegation of bribery by the respondents. Now, this really matters because the judge was deciding whether act of state applied to the pleaded claims and whether any exception to act of state applied to the pleaded claims. This is an appeal against that judgment. Ostensibly, the grounds of appeal and the skeleton argument in support of those grounds were directed to saying that the judge was wrong to decide that act of state applied to the pleaded claims. Appeals are of course against orders made on judgments, and section 5 of the appellant's notice tells us that what is appealed is the order of His Honour Judge Pelling dated the 19th of October 2022, and in particular paragraphs 1 to 4 of that order. And if you would turn up his order at tab 4, bundle page 55, the operative order, the issue he was deciding is the declaration in paragraph 1 that the court has no jurisdiction to try the claim against the first, second, third, fourth and fifth defendants.
Yeah.
And consequently then the setting aside of service of the claim form. That is of course a declaration that the court has no jurisdiction to try the claims as advanced in the claim form and particularised in the amended particulars of claim. Now on this appeal, the appellants ask you, or at least we thought they were asking you, to find that the court does have jurisdiction to try the pleaded claims. And it was a somewhat bold suggestion made by my own friend yesterday that this court might give judgment on some act of state issues in the abstract and then leave it to the claimants to bring forward an amended, for which he must have meant completely rewritten, pleading to try and fit the judgment. That is not the way appeals work. And the paragraph that he plucked from the Supreme Court judgment in Law Debenture to try to suggest that that is the way things might go is absolutely suggesting no such thing. I'll come back to that point later. But the point is, and I do say it matters, and matters a great deal, to identify what the issue on this appeal is, that the judge correctly identified in his judgment in paragraph 1 that he was deciding the application of the first and second defendants and of the third to fifth defendants to orders declaring that the English courts have no jurisdiction over the claim made against them. And he did decide that issue and did so by reference to the pleaded case. In relation to the Sovereign Act issue raised by ground 2 and the Kirkpatrick issue raised by ground 4, that involved him asking himself whether the acts of the Bank of Uganda which were pleaded as ingredients of the pleaded causes of action were sovereign acts, and asking himself whether the claim as pleaded involved a direct attack on the lawfulness of the Bank of Uganda's conduct, in the sense, as the judge correctly identified in paragraph 31 of his judgment that Lord Sumption described in Belhadj, that the issues raised by the pleaded case could not be resolved without determining lawfulness. Yeah. Those are two questions of law raised by grounds 2 and 4, and with great respect to my own friend, they are only open to him to argue as issues in this court if addressed by reference to the pleaded case, and to all of it, no part of it having been withdrawn either before the judge below or in this court. Again, a matter to which I will return. Now,
although we could conclude that some of it fell within the Acts of State doctrine and some of it didn't. And that was Lord Panick's point about one of his other grounds.
That's his attempt. And
it's a commercial act rather than.
But my lord, no, I will address this in more detail. I do not accept that is possible or appropriate in this court, because we are.
Is that because he's tied his colours to the mast of saying I'm dependent on all of these particulars of the unlawful means conspiracy to get home?
That's one reason, Lord, and I'm going to show you that. And the other reason is because sub-paragraph 69M isn't freestanding in a way that separates itself, as pleaded, from the allegations of unlawful conduct by the BOU that preceded.
Okay.
So it's not severable. It's not capable of being freestanding.
Okay.
And Lord, I will trail this point, but your lordships, I'm sure, will understand, bearing in mind the history that this pleading has gone through. It's obvious that there is a very good reason why the claimants did not at this stage of the application for permission to amend, or before the judge below, or on this appeal, actually proffer an alternative pleading which showed how it could be done. Because the problem is that their case, if they tried to confine it just to the allegations against the first and second defendants in subparagraph 69M, is a case that would lose its legal viability entirely. It would be a case which would have fatal problems in relation to allegations of causation, and it would be a case in which the claimants would be unable to show that they'd suffered loss. This goes to the point my Lord Justice Phillips mentioned yesterday, which is how does the case look if one treats, or if the claimants had to treat everything that had been done by the BOU as lawful and in good faith, so that what you have at the end of the day is a sale to the DFCU of assets and liabilities against a background where all the acts of the BOU are on this premise lawful. The answer is that the damage done to CBL in respect of which they make the claim has all happened as a result of all those previous steps. All you have at the end of the day is the purchase out of the.
Yeah.
Does that apply to ground 2? If it's a commercial act, then the court looks at it, even if it involves finding that it's unlawful under domestic law.
My Lord, your lordship is correct, but sorry, my Lord, it depends on what your lordship means by ground 2. If your lordship means by ground 2 only looking at 69M, because my own friend,
as Lord Panic puts it, the sale itself is an act of a private character.
Yes.
And therefore, to use the shorthand,
yes,
a commercial act. Then his submission is the motives for which it was performed are irrelevant to that question. It comes within the scope of what the court can look at. And if the motives were, which may have been what you're alluding to a moment ago, in part to cover up previous wrongdoing, the court can look at that and make findings that there was such wrongdoing and there were such motives, because as I understand it, certainly as I understand his submission, it is that once you're into the non-sovereign act, there's no bar at all on what the court can adjudicate upon.
but my Lord, my learned friend accepts that all the acts of the BOU prior to the P&A agreement were sovereign. So, indeed he did.
Right.
And which is why he was trying to address and addressed only the ground 2 by reference to the P&A agreement, which he says is a private act. I can give you also the reference to the transcript yesterday, where he made that position clear. So in the premise of the whole case going forward, that would mean that in this hypothetical consideration is as to whether there could be act of state applied to part but not other parts, then the claim against the defendants would have to proceed on the basis that all the matters prior to the P&A agreement could not be challenged as unlawful, which obviously is swathes of the pleading, and I'll come back to that.
Right. I understand how you put it.
But my Lord, anyway, as I say, that is for the reasons which I touched on and I'll develop, simply an exercise that cannot be done on this appeal, and which the appellants are not permitted to do, again, for reasons which I will develop.
Because the way it was opened to us, this was effectively a claim for bribery of the receivers to sell at an undervalue. Was that one of the ways it was put to the judge?
The way the way it was put to the judge is actually the way, and I'll come back to this, is the way that it's put in the skeleton in terms of the characterization of the dispute. Paragraph 5 of the appellant's skeleton.
Skeleton before this court or
Before this court,
Yeah.
page 23 of the bundle.
Yeah.
Says this dispute concerns events which took place in relation to the takeover, closure, and sale of the assets of the first claimant. And as I'm going to show you, their characterization of the pleaded case and their characterization of the case for all purposes has been that the dispute comprehends all of those, that there is a continuum from beginning to end. Of which the
My understanding of what Lord Pelling submitted yesterday was that although he accepted that you could have a case in which Kuwait Airways was an example where if you start off with sovereign acts and then they become commercial, his primary case was that all of the acts here were actually to be properly categorised as commercial because they were all part of a corrupt scheme. I don't think he was saying, contrary to what you said a moment ago, I don't think he was saying that all the acts up prior, as it were, to 69M were all sovereign acts.
Lord, page 13 of the transcript of yesterday. Can I just read it? It's one sentence.
Yeah.
Our submission is that the agreement between the first defendant and the BOU acting as receiver was a commercial act, even though we recognise that what preceded it included sovereign acts. I don't recall him addressing you in any respect on any of the earlier acts of the BOU which are pleaded, and pleaded as having been unlawfully effected.
He argued Kirkpatrick in relation to the earlier acts.
Yeah.
Yes, which I'm also going to come to, which is the validity point.
Yeah.
Absolutely, and I'm going to address Kuwait Airways, but
And he's also arguing public policy and Article 6.
and he is,
Yes.
but of course, public policy and Article 6, the premise of them, even to get into them, is that Act of State otherwise applies.
Yeah, follow.
Now, as I say, I've said it twice, but I will say it one more time.
Yeah.
This matters. Why does it matter? Why does it matter that the consideration of the Act of State issues should be considered by reference to the pleaded case? It matters in relation to each of grounds 2 Sovereign Act, 4 Kirkpatrick, and 3 public policy. Because in relation to each of those issues, when you consider what the relevant principles are in terms of application, you have to know to what it is that you're trying to apply those principles. And I will show your lordships why, in relation to each of those, the keeping away from what the actual pleaded case is problematic for the appellants in relation to their appeals. Now, Lords, and the reason at the moment I'm addressing it, as it were, by reference to all those grounds is because this point is of application to all of them. And so I'm just starting, if I may, with matters which are foundational matters which are relevant to each of those grounds, and then I'll then take those and look at the particular ones. Now, my Lords, there is of course a forensic transparency to what my learned friend is doing. Why does he want to characterise the claim in quite different terms? Because the argument that the pleaded case does not plead sovereign acts as the basis for the cause of action is hopeless. And my learned friend effectively accepted that, as I say, in relation to everything other than the P&A agreement. The argument that the determination of the pleaded issues would not involve determining the legality of acts of the Bank of Uganda is hopeless, or as my own friend gently put it in answer to my Lord Justice Popplewell's question yesterday, our position is weaker in relation to non-bribery claims,
Yeah.
he said. Well, there aren't any. There are only non-bribery claims, so that's as far as he was able to go and accept it's in relation to the entirety of the claimant's case. And the forensic ignoring of the claim actually pleaded is also Millen & Friends' springboard to trying to reframe the public policy exception argument. Because again, the correct issue for this court to decide in relation to public policy is whether there is a public policy that mandates the English court to proceed to decide the pleaded claims, overriding the Act of State bar that undoubtedly otherwise applies to the pleaded claims. So the question is, does the Act of State rule apply to the claims in the claim form and amended particulars of claim? Or perhaps more accurately, was the judge's decision that it did apply wrong, but it is common ground that that decision involved only questions of law being applied to the pleaded case, and so effectively this court is in a position to decide the same question. So, having, I hope, brought the appeal back to what it is actually supposed to be about and a correct framing of the issue, can I address some basic points which are directly relevant to both grounds 2 and 4, Sovereign Acts and Kirkpatrick? We said below, and we say again in this court, that this is a paradigm Act of State case. It is a claim which puts at its foundational centre allegations that the Ugandan Central Bank misused its regulatory powers of bank resolution within the territory of Uganda in respect of a domestic Ugandan bank contrary to Ugandan law. And as I've just shown you, the appellants themselves say that the first essential fact is the heading of that section in their skeleton. They say that the first essential fact is that the dispute concerns events which took place in relation to the takeover, closure, and sale of the assets of CBL by the Bank of Uganda.
But why cannot, surely one can split off the sale at the point at which BOU appoint themselves receivers, that their role has changed, their character has changed, they are no longer acting as the central bank, they're acting as receivers, which anybody suitably qualified could be appointed as a receiver. And the sale they then enter into is, at least on the face of it, a private sale of assets. So I'm not sure why one has to say that one lumps it all together and say it all has to be looked at as one thing.
Because, my lord, the premise of the point your lordship has put to me, that it was different, that it was done in a different capacity, that it didn't relate to central bank powers, is not correct. And I'm going to come on to that. And your lordship might think that it might have been relevant for Millen & Friends to show the court in that context.
94, you mean?
Sorry?
You mean section 94?
Section 94, 95, my lord, yes. In
That
terms
just replicates what the receiver's powers will be.
I'm going to. That's exactly what I'm coming to now in terms of looking at those those powers. So as I say, I want to focus on those foundational aspects of as to why we say it is a paradigm Act of State case, which reflect the points I'm just going to deal with. There are four features I want to address, which are relevant to the Sovereign Act point, the point your lordship just made, including the P&A agreement, and also in relation to...
When we're looking at particularly the Sovereign Act point, we have to look at the commercial reality thing. We can't be hidebound by pleading structure, as it were.
This is not a pleading point, Lord.
I fear though that we do seem to be in a bit of a pleading point arena.
No, not on this point. In relation to Sovereign Act,
Yes.
in relation to Sovereign Act, the the need to look at the pleading is to identify which acts are relied on. Then there's the question of applying the law in relation to a jure imperii, a jure justionis, the plier laga, to those. And that involves looking at other matters, including which I'll come to in a moment, or after the short adjournment, the source of the powers, to understand the nature of what it was the Bank of Uganda was doing. On that point, I never like to say to the court in answer to a question, can I come back to it? But I'm not far away from that. Can I? But before going into them, can I just identify to the court the four elements of the alleged facts and pleaded cause of action, which we say are important, critical, and they can be all taken from the face of the pleading, but critical to then addressing the Foreign Act of State questions. They are, first, that the allegations are made of against the, not against in the sense of being a defendant, but are allegations as to the Bank of Uganda's conduct, which is the central bank, which is part of the state of Uganda. Second, that they are allegations of misuse and abuse and illegal exercise of regulatory powers of bank resolution. Third, they are all alleged to be within the territory of Uganda in respect of a domestic Ugandan bank. And fourth, alleged to be contrary to Ugandan law. And what I will do next is just to spend a moment on each, so that your lordships have, in terms of the relevant facts and material in relation to those, then the platform for then the consideration of both the Sovereign Act question and Kirkpatrick.
Let's do that at 2 o'clock.
Oh, yes.
All right.